All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court is seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Johnson versus State of Florida, number 2024-0380. Whenever you're ready.
Good morning, Your Honors. Benjamin Eisenberg on behalf of the petitioner, Corey Johnson. We're here today to resolve a certified conflict between the 4th and 2nd District Courts of Appeal and answer the question that was mentioned within but left undecided by this court's decision in State v. Purdy. That is, whether a juvenile's consecutive life sentences with review imposed for offenses committed during a single criminal episode violate the Eighth Amendment. It is Mr. Johnson's position that no penological purpose is advanced by the continued incarceration of a juvenile who has served 25 years in prison, the time required under Section 921.1402 for judicial review, and has been found by a court to be rehabilitated and fit to rejoin society.
If I could interrupt you just briefly, you mentioned Purdy. Now, you're not asking that we recede from Purdy.
No, Your Honor, not at all. I mean, State v. Purdy.
So that's purely, so you accept and the statutory interpretation in Purdy.
Right. State v. Purdy the opinion was very careful in limiting itself to the issue. Right, to the issue of statutory. But there was a footnote 2 within State v. Purdy, which recognized that there could be issues with regards to proportionality. And so that's the answer, that's the question. And so that did not foreclose Mr. Purdy from raising Eighth Amendment issues. And in fact, Mr. Purdy did raise his Eighth Amendment issue later and was subsequently granted relief and was released. It's petitioner's position, though, that when you have a juvenile in the position previously mentioned that has served the 25 years and been found rehabilitated fit to reenter society, such juveniles should be eligible for the law's mercy as stated by the Florida legislature, because it is apparent at that point as offenses do not reflect permanent moral failings such that continued incarceration is disproportionate. And as the Supreme Court stated on page 71 of Graham, a sentence lacking any penological justification is by its nature disproportionate to the offense.
Well, let me ask you this. Now, I know there's a dispute about whether a couple of the offenses, the attempted murder offenses are non-homicide offenses. Okay, I'll leave that aside. But we know that the defendant here is a murderer. And we know, don't we, under Miller, that there's no constitutional impediment to putting a person who committed a murder as a juvenile away for life if the judge goes through a proper evaluation of the circumstances, including the youth of the offender. Isn't that correct?
Correct. Jones
all right. So we know that. We know we have a murderer. We know what Miller says about what's required for that. And so one way to look at this, and I know this is not the way you want us to look at it, but one way to look at this is that the trial court, the sentencing judge, looked at all that and decided that he wanted to put this defendant away for as long as he could put him away. And that's what he did. And he structured the sentence to accomplish that result. And he structured it consistent with what the statutory structure would allow. And so there you have it. And so he's there. You cannot remove the murder aspect of this from the overall situation. I understand we've got these other offenses, for which are at issue here. But the whole framework here is based on the murder. So tell me why that would be a wrong way to look at it. I know you think it's a wrong way to look at it, but why is that not a sensible way to look at it?
But first and foremost, just in response to the state's argument and addressing this court already held in Grenine that attempted murder does constitute non-homicide offense.
But what I say, actually, I think I'm inclined to agree with you. I think I'm inclined to agree with what the court unanimously said there, but that's a different discussion. Right. But that doesn't affect the question I have just asked you. That's got nothing to do with it, actually, because we start out with the premise that he is a murderer. There's no question that he's a murderer.
Correct. There's
no question that is the kind of the most serious offense here. And I don't know why we wouldn't just look at this. That's driving the train here, and that's perfectly within the discretion of the trial court judge. There's no constitutional impediment to the trial court judge putting him away for as long as the state law will allow, assuming that he's gone through what is required. And you're not challenging, I don't think, what the trial court did in evaluating how he would impose the sentence. So put that thing about the non-homicide of what category the attempted murder convictions fall into. I don't think that's relevant to if I didn't make that clear, I make it clear now. That's not relevant to my question.
Justice Kennedy, no, I understand your question. What I was getting at with that is just that the homicide count is count one, and so that is the first count of which he has to serve. And so the legislature has determined through 921-1401 and 921-402 that the appropriate sentence in that case, it can be life, but life with review. So viewed in isolation, that complies with the Eighth Amendment to the degree that the defendant has not received a mandatory life. What cannot be forget, one of the things that goes into Roper, Graham, Mill, and these types of cases is that because juveniles are different, you can't just let the heinous nature of a crime overpower it. And what I was trying to get is that while he did commit a murder, yes, that applies to count one. Counts 2 and 3, which are the consecutive sentences, were not murder, and those are non-homicide offenses. And so as to count one...
Well, can I ask you this? And I don't know the answer to this. I need your help. Does Florida law have any requirement concerning the order in which consecutive sentences are imposed?
I do not know. I think it's up to the judge's discretion in that regard. And in this regard,
you think there is discretion?
Well, I think in this case, the judge gave. I'm not
asking about this case. I'm asking a question of law. And again, if you don't, I realize this.
It wasn't argued, so
I understand. Okay.
I'm not entirely sure.
But assuming that I understood you correctly, and you're thinking that the trial judge can order those however the trial judge chooses, would this be a different case if it had been ordered differently, so that the sentence for the murder was served consecutively after the sentence for the attempted murders?
I don't think it would change that much to the degree that now we're talking about impacting the non-homicide counts, of which Graham would clearly apply. And so Graham envisions that you have a meaningful opportunity for early release based on maturation and rehabilitation. And so in that instance, the entire purpose of having the sentence consecutively is to, as you said, manipulate the statute in such a way that the defendant can prove that he is rehabilitated and fit to reenter society and not be able to get out. And that's the problem that we have. And so then it would make the relief as the non-homicide counts, as the court said in Mack,
it seems like you're just trying to leverage, though, this kind of statutory anomaly of, the fact that they get this review after the 25 years that they weren't constitutionally entitled to. And you're using that finding of rehabilitation to then say, well, you can't have the other sentences. But it seems like the problem here is more of a kind of, maybe someone needs to rethink how that statute should be written to cover situations like this, rather than turning this kind of statutory glitch or anomaly or kind of, marginal application into a constitutional problem.
Well, Chief Justice Muniz, to that degree, I disagree in that the whole reason we have these types of laws, the foundational stone basically of Miller, Graham, Roper, and these types of cases, is that the line of cases that certain punishments are disproportionate when applied to juveniles.
Right, but hold on. But in the case of a homicide, the murder, all that the person is constitutionally entitled to is, at the sentencing phase, sort of a consideration of the immaturity and whatever, and then the judge still has the constitutional discretion to sentence the person for life without parole, right?
Correct.
And so whatever review they're getting after 25 years here is just sort of like legislative grace.
Right.
And so you're trying to turn that legislative grace then into a reason why, to invalidate these consecutive sentences on the back end.
Well, Your Honor, I wouldn't say that it's legislative grace. I would say that in Graham, the court left it to the states in the first instance to determine what are the proper procedures for dealing with Graham and Miller violations. This was the matter that our legislature decided. And one of the things that's important about the statutes in 921-1402 is that it's not simply a mandatory mitigation based on you served an amount of time, you're out. It requires certain findings that someone has been rehabilitated. And just to go back to what the penological rationales for punishment are, there's retribution, deterrence, incapacitation, and rehabilitation. Why do we have these? Because there's three qualities as juveniles that differentiate them from others: immaturity, vulnerability, and reformability. So what happens here with the statutes is we get to look into what someone has done over those 25 years. And whereas the United States Supreme Court has already recognized that juveniles must be treated differently, and even as recently as I quoted in Jones versus Mississippi, the court continues to say that youth matters in terms of sentencing. But when we have someone that's already served 25 years and there's been a finding that that person is rehabilitated and fit to reenter society, then the penological purposes, which already collapse as part of the Graham and Miller analysis, collapse even further, because we have a person that when you look at those deterrents, juveniles, even Roper said that there's minimal deterrence as applied to people with a death penalty.
But Graham itself said that when it comes to penological purpose, including retribution, it says that when you're talking about someone who commits homicide plus non-homicide, that basically you can't really separate the homicide in the sense that whatever punishment you choose for the non-homicide is going to kind of reflect that baseline. And so I don't think that Graham itself accepts the premise that just because there's this hearing at 25 years that sort of retroactively kind of wipes out the retributional or retributive justification for the way the original sentence was structured.
Well, I think Graham was saying that to the degree that when they were going through an analysis of whether this was a rare practice, they really didn't consider life sentences for non-homicide offenses where the defendant also committed homicide to the degree that the homicide had overpowered it. And that's the fear that we have in these types of cases, and that was evinced in Roper, Miller, and those types of cases. Even in Graham, they said the courts must respect human attributes, even of those who commit heinous crimes. And I do want to say in this case, what happens to the victims in this case was a tragedy, but the focus in terms of the Miller Graham analysis is on how juveniles are different. And so in terms of retribution...
A lot of our discussion so far has involved sort of shifting back and forth between Miller and Graham, which, you're right, treat youth differently with respect to non-homicide offenses. And this offense, which is both a non-homicide offense and a homicide offense. So I feel like perhaps we should stop clouding that issue. Youth is different. My question that arises from that is, do you concede that Mr. Johnson will have a sentence review after 50 years?
Under 50 years, there's also, as I pointed out in my brief, there's the administrative time in terms of actually scheduling a hearing, getting a ruling from the trial court.
You concede that there will be some review at some point, right?
He'll get review after 25 years of murder count, and then if he's found rehabilitated and fit to re-enter society, he'll have to serve another 25 years to get another review.
How is that not the end of your Eighth Amendment argument?
Because I think the analysis changes with regards to a defendant has proven to a court that they're rehabilitated and fit to re-enter society.
I'm sorry, isn't it just the case that our statutory scheme could call for review in 30 years, could it not, and still be consistent with the Eighth Amendment?
Right. But
it could call for review in 50 years and still be consistent with the Eighth Amendment, couldn't it?
Under the Miller and Graham, yes, but this was the legislature's determination, and I think it's important.
And for the murder, it could call for review never, and still be consistent with the constitutional requirements. Correct?
Correct, but the legislature has made that determination for these murder counts. And keep in mind, not every murder defendant is entitled to review. There are disqualifications, especially if someone has committed a prior event and another incident, but Mr. Johnson did not have any.
Counsel, let me ask you something about this. That when I look at this, it seems like your whole argument is based on speculating. You're speculating about what the consequences would be if at the first 25-year review, it is determined by the reviewing judge at that time that the defendant has been rehabilitated. We don't know that that's going to happen.
Well, that decision's already been made at the outset, and that was one of the problems with, like, Graham, for example, is that there could be some defendants, and Miller for that matter too, there could be some defendants who are incorrigible or irredeemably corrupt. But the problem is that decision's being made at the outset. So now it's the judge at the initial sentencing is making the decision that regardless of what he does,
but what I'm suggesting is that the constitutional violation you are claiming really depends upon that first review resulting in a determination of rehabilitation, and that hasn't happened yet. And we don't know that it will happen. We have to speculate about if that happens, then there would be a constitutional violation. I think that's your argument, is that if that happened, then there's a constitutional violation. And that just strikes me as kind of odd that we're speculating about that.
Well, my issue is that they've structured it in a way that guarantees no matter what, he's going to have to serve.
Well, no, but there's no constitutional, it doesn't guarantee a constitutional violation. What you're saying, it creates the possibility of a constitutional violation, correct?
Correct. It creates a situation that runs afoul of the Eighth Amendment to the degree that it makes his release on the homicide count entirely illusory, but most importantly for the non-homicide counts, again, I don't believe that it serves any penological purpose. Justice Sassen?
Yeah, I just want to understand your argument, because it seems to me that based on the rule that you're asking us to adopt, that it was essentially a constitutional ban on consecutive sentences for juveniles at all. So where's the scenario where it's not unconstitutional for consecutive sentences?
Well, one of the things I mentioned in my reply brief is that the second DCA, which is the court that authored Mack, also authored Garner, which came out later, and they said that defendant, it was different. They distinguished Mack because it was 2 homicide counts. Now, I'm not going to sit there and concede it's not the case before us, but that was the case where the second DCA who authored Mack said it was distinguishable because there were 2 homicide counts, and that increased the person's moral culpability. That said, in this case, and just to kind of wrap things up because I realize I'm into my rebuttal, just with the penological rationales, the issue I have is that deterrence is already lessened as it regards to juveniles because of their immaturity and vulnerability. Incapacitation for Terrence Graham, the court said that he needed to be removed from society for a bit in order to show that his escalating pattern wouldn't continue. If someone's been rehabilitated and fit to reenter society, that has been done. Rehabilitation, of course, has been a finding of rehabilitation in that circumstance, so the defendant is rehabilitated. And lastly, retribution. The legislature has determined in that regards that 25 years is a sufficient amount of time to determine how that defendant's doing. And so my position in that circumstance is if it's been 25 years and they made that finding, that there's no longer a penological purpose served by the non-homicide counts that are consecutive to the homicide count. I'll save the remainder of my time for rebuttal. Thank you.
Thank you.
Thank you, Mr. Chief Justice, and may it please the court. Florida has a scheme for sentencing juvenile homicide offenders that is.
I'm sorry, counsel, could you speak up a little bit? I don't know if that's
that. Yeah.
Not
so
turned
Florida has a scheme for sentencing juvenile homicide offenders that is substantially more protective than what the U.S. Supreme Court's Eighth Amendment jurisprudence requires. I agree with many of the comments from the court thus far. Under Miller, the only protection that Mr. Johnson received as a homicide offender was the protection of Miller, which says that you are entitled to a discretionary sentencing hearing. He got that. Now, our statute goes farther, and it also extends some Graham-style protections that it did not have to extend. That's the point about legislative grace. And they are piggybacking on that legislative grace to try to make the point that, well, as soon as a homicide offender is found rehabilitated, that necessitates that person's release. Some of the hypotheticals, I think, show the problem with that, but in particular, taken to its logical end, their argument suggests that if a homicide offender could show that after 1 year or 2 years or 30 days that he was rehabilitated, the Eighth Amendment would necessitate his release. And there is simply no U.S. Supreme Court case that holds that. At most, there are some cases that suggest in the non-homicide context that a non-homicide offender has to have the opportunity in their natural lifetime to show that they're rehabilitated. So at best, even treating this gentleman as though he were a non-homicide offender, at some point before he reaches the age of his expected death, he would have to have the opportunity to show that. The Eighth Amendment certainly does not require his immediate release on showing rehabilitation. So I'm happy to answer any of the questions that the court may have about the core issues, but if you don't have any questions about that, I'd like to just spend a few moments trying to plant the seed on the point about Gridine. So Justice Kennedy, you raised the point. It's your view that Gridine was correctly decided. You voted in the majority in that case. We think that
I might have been wrong. I mean, the fact that I voted in the majority is not really I could have been wrong.
I'd like to take a crack at convincing you. It doesn't matter in this case because Mr. Johnson is a homicide offender one way or the other by virtue of succeeding in killing the 13-year-old. But it might matter in a future case where we were just talking about attempted first-degree murders. And to my mind, Gridine is a poorly reasoned decision because it imports state law principles about statutory interpretation and a logic that is divorced from how Graham itself defines the line between homicide offenders and non-homicide offenders. So Graham is very clear at page 69 that the difference between a homicide offender and a non-homicide offender is whether the offender killed, intended to kill, or foresaw that.
Did you say 69 or 59?
At 69.
Okay.
So this is the test from Graham.
I mean, it kind of bounces around, though. I mean, obviously that one sentence is super strong for you, but then it's got other parts where it talks about someone who commits a homicide. And then I think Jones, in its characterization of the previous stuff, was talking about someone who commits a homicide. So, I mean, part of the problem is that it's sort of a kind of, I mean, I don't say this arbitrary in a sort of super pejorative way, but the Supreme Court's just sort of making this up. And so they, you know what I'm saying? It's like we're not really looking to any sort of objective thing. We're just looking to sort of how they're characterizing it in their opinions, which may or may not have been thought out with this particular question in mind.
Yeah, so I really think I can convince you of this. So it is, they did pluck it sort of out of the ether. This whole line of jurisprudence deviates from original meaning. It's something that they invented under evolving standards. But there's a reason that Graham has the articulation that it has. Killed, intended to kill, which is attempted first-degree murder in Florida, would involve an intent to kill. So it falls within Graham's definition. Now, the reason that Graham defines it this way is because that's how Terrence Graham defined it himself in his opening brief in the U.S. Supreme Court at footnote 1. And he had a very important strategic reason for doing that. He said, and it's quite clear in that footnote, that attempted murder would be a homicide offense. And the reason he made that strategic judgment was because he had to show the court there was a national consensus in that case against using life without parole for non-homicide offenders. That's what the whole case is about. The problem for him was that there were a bunch of LWOP sentences for attempted murder. And so what did Graham do as a strategic matter? He convinced the court to define homicide offense as involving attempts, so that he could say, don't worry about those LWOP sentences for attempts. They're for homicide offenders.
Well, but counsel, if we look at this in context and what's actually said there, there's a reference that points us back to Inmate, and that language about killing, intending to kill, foresee that life will be taken, that comes out of this context where they're talking about murders. Okay? They're talking about murderers who are principals, non-trigger man murderers, correct?
In Inman, yes.
Well, but that's the whole context. That's the soil from which this comes. And so I think to look at it, and then when they go on down there and they're further talking about it and explaining why this distinction they're making makes sense, They talk about the severity and irrevocability.
Yes.
Okay. And then they talk about this is because life is over for the victim of the murderer, but for the victim of even a very serious non-homicide crime, life is not over and normally is not beyond repair. I don't know how you can reconcile what they say there with the point you're making.
So there's more to say. So Justice Kennedy and some of the courts out there throughout the country that have said that attempts are non-homicide crimes do point to the language about the irrevocability of the death. You can't bring the victim back, but that's not all that the U.S. Supreme Court said. It also pointed to moral depravity. And moral depravity applies equally whether you succeed in your intent to kill or you fail in your intent to kill. You are every bit as morally culpable. So Mr. Johnson tried to kill 2 more people. He failed. But in terms of the moral blameworthiness, it's identical. And Graham says both the moral depravity and consequential harm. So what you were pointing to is the consequential harm. But that wasn't all that Graham talked about. But let me make
where do they say anything that other than this general language here on 69, page 69, and yeah, I've got it. Right. I know what you're talking about.
Sure.
But where else do they say anything where they take back what they say about irrevocability, and where they take back or qualify what they say about life being over? Point me to somewhere in the text of this opinion or some other opinion from the U.S. Supreme Court where they do that.
No, they don't, but they say that there are two rationales. But two additional points. So the court also relies on a study by Professor Anino, A-N-N-I-N-O. You can find it online at pages 3 to 4. It defines, and the court relies on this a number of times, it defines an attempted homicide as a homicide. It says that attempted murder is a homicide. The court relied on that study, and I think it's fair to say it relied on the definition as well. And then the last thing I'll say, and then I'll cede the floor, is that if you look at pages 80 to 81 of the court's opinion, this is where it's talking about international consensus, and it has to deal with the state of Israel. The state of Israel had imposed LWOP sentences for both murder offenses and attempted murder. And the court characterized what Israel had done was imposing LWOP for homicide crimes. And it in fact said that there is no other nation in the world other than the U.S. that imposes LWOP for homicide crimes. It could not have said that if it thought that Israel's LWOP sentences for attempted murder were for non-homicide crimes. It just couldn't have said that. So there are all these indications out there, and if you just looked at them, as a matter of state law, yes, Tipton is out there. It says that if you're doing statutory interpretation, homicide means just completed homicide, not attempts. But we think that that is not the constitutional test, and that Gridiron was wrong for that reason.
That when we think about this from a conformity clause perspective, regardless of how the state defines homicide versus non-homicide, is it our task to just faithfully apply Graham's characterization of what's homicide and homicide, not deviate from that?
Yes.
Yes. Can you help us? Sorry, go ahead.
No, please.
Can you help us understand what the significance of this is? Because as long as the legislature chooses to have these reviews, even if we agree that the attempted murders are quote unquote homicide offenses, his argument would still be, well, once you've shown that you're rehabilitated and whatever, then it becomes disproportionate to keep you incarcerated. It seems like the logic of that would be for it doesn't matter what for. So what's the universe of cases, as long as we have the statutory scheme that we do that kind of overprotects homicide offenders, like what difference does it make?
So there would be applications where this would come up and it wouldn't matter. So imagine that count 1 here was an attempt. So you had 3 attempted murders. And the judge ran all the sentences consecutively. So the release would be at the 75-year mark. I think your cases like Henry would suggest that that's a problem, that is de facto life without parole. We think the right answer is no, that's a homicide. That's a homicide offender. And so that would be perfectly fine.
I mean, after the first review, if he's found rehabilitated, then it wouldn't matter, right?
Well, I think under their theory,
right?
Yeah, under their theory, it might not matter. But he's got multiple arguments in this case. He's also got an argument about a 50-year minimum term being a de facto life sentence. And our frontline answer to that is, well, it doesn't matter because he doesn't get the benefit of Graham. So the point about Gridiron matters quite a bit to that threshold argument, because we could not make that argument if all of his crimes were attempted first-degree murder. We'd be more limited. We'd have to say 50 years is not de facto life as a matter of the actuarial tables. But I think, Chief Justice Muniz, there are more applications than just those. I think it has a bunch of applications, and so it would matter. But as I said at the top, you don't have to decide this issue in this case. But, we do want to flag this point because it will matter in some future case, and we'll probably be back here talking about Gridiron. And we just think it's...
Well, but in addition to not having to, wouldn't it be totally gratuitous for us to decide we basically accept your position? It seems like it would be totally gratuitous. I mean, we could decide this in the state's favor and uphold what the district court has done without reaching that issue.
I think you certainly could. But one of the arguments that my friend has made today is he said, well, you have to treat, I think you exposed this with the hypothetical about switching the order of the consecutive sentences, but he's made the argument.
What do you say about that?
Yeah, I think it's a very fine point. I think it lays bare the illogic of the argument, but an additional response to my friend's point is that, it doesn't matter that the second offense that he's serving, it's just another point to say, well, even that is a homicide offense. So you could say that you don't have to, because one way or the other, Graham says that this is a homicide offender. So there are many reasons we win, and this is not dispositive, but it's something to be thinking about, I think, and in some future case we'll be back here talking about Gridiron. So I've taken this pretty far afield. If the court has any questions on the rest of the merits, happy to discuss them. If not, thank you for your time.
Thank you. Appreciate it.
Your Honor, first and foremost, there's no reason to depart from Gridiron. As I mentioned in the reply brief, every court that's addressed the issue has said that it is a non-homicide offense, except for one unpublished decision from a different state. And in any event, as Justice Kennedy mentioned, Graham talks about how there's the irrevocability of death as against attempted murder. And as devastating as the offense is as to the victims of the attempted murder, they do live, whereas the victim of the murder does not. I do want to wrap up just to get back to the original point. I don't want to conflate the argument that the state was trying to say, well, if you took my argument to its extreme, it would mean that someone that served 1 year, 30 days would be able to get out immediately if they're found to be rehabilitated. That's not our argument. There are 4 penological purposes for sentences recognized in Graham and Miller, and one of them is retribution. And the statute doesn't say you get review immediately. It says that in these cases, including attempted homicide and homicide, the review is after 25 years. So our argument is that's the determination. And the decision of the legislature doesn't begin certain weight. I mean, this court in Horsley said that the remedy for Graham and Miller violations is to abide by the provisions of Chapter 14-220, because that is the voice of the legislature in how to remedy these Miller-Graham type violations. But with regards to retribution, it can't be forgotten that the goal of retribution is only served if the punishment imposed is warranted by the offender's true level of depravity. So here it's not 3 homicide offenses, it's 1 followed by 2 homicide offenses. And if that person has been found to be rehabilitated, then while society is entitled to impose severe sanctions on a juvenile offender, and 25 years day for day is a very serious penalty, to express its condemnation for the crime and to seek restoration for the moral imbalance. The heart of the retribution rationale is that a criminal sentence must be directly related to the personal culpability of the criminal offender. And so here we know from the case law that the culpability of juveniles is lessened, youth matters, and when someone has been found after serving 25 years in prison to be rehabilitated and fit to re-enter society, they should get law's mercy. And all we're asking this court to do is to make his sentences concurrent, so I'll have review of all the offenses from this criminal episode in one review hearing. Thank you, Your Honor.
Thank you very much.